Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed Charles Gormley, an attorney in his own office based out of DC. Charles is not only an attorney, but he has also invested and been a servicer for others in the industry, both in DC and in Maryland. In today's interview, Charles shares comparison of the DC and Maryland tax sale processes. His varying perspectives of the industry really sheds light on these two states, so sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Hi, everybody. Welcome to this episode of Tax Sale Insiders. I'm Brian Seidensticker, CEO of Tax Sale Resources. And with me today, I have Charles Gormley. He's the attorney, also an investor, which is great to have an investor here with us today. And then also a servicer. And for those still learning the lingo for the industry, we consider a servicer somebody that is investing for third parties as well. So Charles, welcome. Thanks
very much, Brian. It's good to be with you.
Thanks for joining us. I guess it's safe to say you're kind of a jack of all trades in the states you're active in, being on the attorney side, the investor side, and also advising or investing, for third parties as well.
Absolutely. I work in the Washington, D.C. and Maryland area. We service a variety of different purchasers. We've bid for them. I've purchased on my own account. And we've helped third-party institutional buyers from the largest to smaller organizations with their liens here in the DC and Maryland area.
So DC and Maryland, so I know they're I guess similar in the fact that they're both, would you consider them both technically lien states?
They're both lien states and they're both judicial foreclosure states.
So they're similar, but like any two states, when you compare them, the similarities are different enough that just because you're active in one doesn't mean you take that same model to the other, correct?
I would completely agree. DC, because it's our capital, people have a lot of impressions about it, but it's a small city. There's fewer than 700,000 people here. So the county in Maryland that I live in is larger than DC. And there's also some misconceptions because the city's changed a lot in the past 20 years, so it's rich. And the universe of liens is shrinking while the value of the collateral is going up. So it remains very popular, particularly with large buyers, because the collateral is so valuable, but it's a shrinking marketplace. Maryland, very different. Maryland is really three different types of sales in my experience, where you have the large suburban counties, Montgomery, Prince George's, Howard, those sorts of counties. Then you have the rural counties in Western Maryland and on the shore. And then you have the city of Baltimore, which is an enormous sale and a beast all to its own with different rules.
Beast is a good word for it. Well, I want to dive into those details and differences in more detail, but real quick, I guess, just so our viewers get a little better understanding of why you're an expert. You obviously are an attorney, you know what you're doing, but can you give us a little background of, how did you get into the industry in general? Because I've yet to come across or talk to anybody that grew up with aspirations of becoming a tax sale investor, a tax sale attorney. So how did you come to be in this space?
Absolutely. So it's interesting. The very first introduction to a sale I had was in 2004 in DC. I'd been a practicing attorney for about a decade at that point, and I'd look at the board with all the cases that were in front of judges that week, and there was always this universe of cases in one courtroom with plaintiffs with unusual names, XYZ tax buyers, 1, 2, 3, tax funding, whatever the name of the the company was. And I said, well, this is interesting. I'm in this building all the time and there's something going on that I don't understand. So I went and I checked out how these judicial foreclosures on tax liens were unfolding. And then I went to my first sale. And that sale was in DC. Contrary to all the advice I give clients and all the advice I'd give here, it was incredibly successful. Probably the most lucrative sale on my own account I've ever been to was my first one. And then I made the mistake of thinking then that I was an expert, and I wasn't. And so you learn quickly in this business that there is a luck factor in it. And then I started investigating sales in Maryland, going to some sales. My parents at that point were retired in Florida. So I went to a couple of sales back when there were still more live sales on some of the smaller Atlantic counties. And I went to some of those sales, figured out what was going on there, helped one of our institutional buyers when they were investigating going to Indiana for sales. So looked at a couple of other jurisdictions, but then pretty much have stuck with our home cooking in Maryland and DC.
Got it. So you ventured out into the other areas and found that sometimes it's better to stay close to home.
Absolutely. Yeah.
We kind of already answered this, but I'm going to reiterate it. As far as, I want to focus on differences between state, because that's one thing that goes lost to most content that's out there today is you learn tax liens and you know it nationwide, which couldn't be further from the truth, right? And so I'm gonna try to focus on, okay, this is how DC works. How is that different from Maryland and vice versa? And you're in a very unique position of understanding both, extremely well. So we'll start at the basics as far as tax liens versus tax deeds. Both Maryland, you consider both Maryland and DC both tax lien states because they do have a separate judicial foreclosure process, correct?
Absolutely, yeah. They're both lien states. They both have a similar 4-month redemption period where nothing can happen. And then after that 4-month period, we'd go into a judicial foreclosure process, and that becomes very different. And even in Maryland can be different depending what county you're in and what type of collateral you're dealing with.
Got it. Okay. Well, let's talk about the sale process first, and maybe we'll talk about Maryland. How does Maryland sales conducted? Are they live? Are they online? Is it premium bid down, et cetera? And then can you describe how that's different in DC?
Sure. So we're still at a point where about half the sales are live and half the sales are online. In the larger suburban jurisdictions, they're almost always online, and those online sales are typically single bid sales where you're just submitting a spreadsheet. They're not dynamic, they're not updating. We have a couple of counties that are still on the Real Tax platform, and that is a dynamic bid where the clock is sort of running and you're entering bids. But for the most part, buyers are submitting spreadsheets and they are told an hour later or a day later, this is what you won. And so that's one universe. The rural counties are typically live. It's going to be interesting to see the degree to which COVID is pushing them towards an online process. About half our sales in Maryland were canceled this year or postponed, but postponed till next year, so the same effect. A few were postponed into the fall. In Maryland, almost all of the sales are held in May and June. We don't have a process where you can spread your money out, you can spread your purchasing out. You're very concentrated in a 60-day period. A couple of outlying counties, but very concentrated at the beginning of the summer. So then you have those the rural counties, still small, still largely live. We have one county where the auctions on the back of a pickup truck, where, you know, you'll have a guy in a cowboy hat doing old school, high-speed country style auctions, and then other jurisdictions where it's just the treasurer of the county reading off the list, low and slow, getting them out. Then you have Baltimore, which is over 10,000 properties typically, online. The sale itself is very smoothly managed. I think Grant Street's still the vendor on the Baltimore sale, and it's a process that for large buyers and small buyers, I think, is very manageable. The redemption process dealing with the city, not as smooth. Once you're outside of the bidding platform, it's not as smooth. What I think is the unique feature of Maryland is that in most counties, not all, but most counties and certainly larger counties, the bidding is done by high bid premium. So 20 years ago, and this was even still the case when I was first going to sales, the bidding would get out of control because for a certain to redeem property at a high interest rate, the bidding would go up, you know, to $10 million on a $100,000 house because people were just trying to get the liens. And there needed to be some way to control that. And so the way that it became controlled is with a high bid premium process. The high bid premium is essentially the non-interest bearing portion of what you pay at the sale, and it's 20% of anything over 40% of assessed value. So if you have a $100,000 property, anything you bid over $40,000, you have to pay 20,000 of it, or 20% of it, excuse me, to the county as a non-interest bearing premium. You get that back on redemption. That's a deal between the certificate buyer and the county. The property owner doesn't know anything about it. They might know about the actual bid, but the high bid premium isn't particularly relevant to them at that stage of the process. That has the way of forcing interest rates down.
Right. So is the real quick on that. So the other portion of that overbid that you pay, so up to that 40%, right? And then, you know, I guess the rest of the amount above that is you're bidding that, but just you don't necessarily have to pay that at the sale.
Correct. And you don't even have to pay the 40%. So all you're paying at the sale is the tax amount and then the high bid premium, the 20% of anything over 40% of assessed.
Okay. Is that other portion ever due during the foreclosure process that it's due or anything like that? Is it so?
The bid, all that's happening with the bid is that number is locked in as what you will pay the county when you get all the way to the end of your foreclosure. So when you get an order foreclosing the rights of redemption and you give that to the county, they then say, well, remember that sale a year ago, you promised to pay us $100,000 for this property. You only paid 10 at the sale. We'd like the remaining 90.
Right.
And then they'll give you your deed. That overbid then is available to third parties. The county doesn't get to keep the overage between all of the taxes that were due. So the property owner can petition for it. Condo or homeowners associations can petition for it. The bank could petition for it if there's a deed of trust on the property. So that money can sit there and folks can try to get at it. We do not have a highly developed overbid industry here. I know in some jurisdictions there are folks whose sole business is that. Mm-hmm. I don't see that at the moment as a place where there's a lot of activity. Got it.
But you can't actually request that overbid until after the foreclosure process is complete and those funds have been paid.
Correct.
So it's not something that if folks want to pursue that, you can't go immediately following the tax sale and go to the county and say, overbid is $40,000. I want, work with, I guess some models are out there as an attorney will work with the previous owner or mortgage holder, et cetera. they have to wait until that actual foreclosure is complete before they can, lay claim.
Correct.
Got it.
Correct.
Okay, so I guess the key of all that is that other amount that you're bidding is not monopoly money. It will be due at some time. So for anybody that's purchasing these and expecting to get the real estate, which in most cases, well, I guess I'll let you tell me how often that actually happens, but that amount is going to be due. So whether you're purchasing at the sale or in what's becoming more popular, purchasing on the secondary market, Charles, those are key numbers to keep in mind, because those are dollar amounts you're going to have to come up with in order to get the deed when all is said and done.
Absolutely, Brian. I think that in Maryland, the bidding is the place, and this is true, I'm sure, nationwide, but definitely in Maryland, the bidding is where all of the mistakes are baked into the cake the minute you leave the auction. And I think for a lot of newer buyers, particularly if they're coming from more prosperous areas, if you go to some of the more economically challenged parts of Maryland, you may not believe that there's a house that you can't sell for $25,000 or $15,000, but I've been that guy. I've been trying to sell that house, and it's stripped. There's no metal, there's no copper, there's no toilets, and there's no market for that property because of what was bid at the sale.
Right.
And so it's really a place to be careful. And I think in the current low interest environment where people are chasing yield, we're seeing bids that are not going to withstand the foreclosure process.
Got it. And that's the hard part of a long redemption and foreclosure process, is the property might look great and totally worth it the day you bid on it, right? But then the property gets abandoned, nobody lives in it for a year. Eventually somebody comes and strips the copper out of it, and what was $100,000 house, you can't even rehab it.
Correct.
For that amount at the end of the day. So that's the giant risk, right? That not all investors are taking. The day you buy that lien, you hope the property, continues to be in the state that it was, assuming everyone did the right thing and looked at the property in the first place, which is something we always recommend, but not everybody follows good advice. I want to, just because I don't want to forget, and then we can dive into how that's different from DC. You mentioned Maryland's sales this year were canceled. Did you mean 2021's are canceled and they're postponing in 22, or 2020 was canceled and I guess 21 is still up in the air?
Great question. And I was unclear. No, it was that 2020 got, half of 2020 got canceled.
Okay.
A couple got pushed into the fall of 2020. I don't think the counties that canceled last year can withstand another year. So I am anticipating a pretty robust season this year. They might get pushed out of May into June or July, but I don't anticipate that the counties that canceled can go 2 years without a sale.
Do you think, and I guess if you don't know, that's fine too, but do you think they'll basically have 2 years worth of liens that they sell in one sale? Obviously there's going to be overlap. Some properties are delinquent every year, right? But or are they going to do a catch up where they do just 2020 sale this year and then maybe a supplemental sale? Or do you have any idea what that?
I don't anticipate supplemental sales. I would anticipate that they'll roll up the taxes, and you'll have liens with multiple years. One of the good things about Maryland from a clarity perspective is they don't sell the same property over and over again. Mm-hmm. If there's an active lien out there, until it's either voided by the passage of time or has gone to title through the process or redeemed, they're not going to resell it in subsequent years. So you don't have multiple liens out there on the same property.
Got it.
With different purchasers.
So in short, the quantity of product, assuming they have their sales this year, should be a bit higher. How much higher? I guess you don't know how much overlap there is, but it should be higher than it would have been typically in 2019 if it stayed the same, right?
I would think so.
Excellent. Okay. All right. I guess let's dive a little bit into okay, so we understand how Maryland's bidding process works. How does that differ from DC?
So DC's different. We use the term in DC, we use the term surplus as opposed to high bid premium. And the bidding in a DC sale will start at the amount of taxes and penalties, whatever the tax account is on the day of the sale. And then anything over that amount is a non-interest bearing surplus. So the taxes on the day of sale, those earn 18% annually, but the surplus is non-interest bearing. The difference is wherever the bidding ends that day with the surplus, that's it. There's no money that you owe other than sub-year taxes on the bidding process in DC. So you know the money you're putting up that day. As a result, it can be more expensive. You're putting your surplus up within a week of the sale. So it's a much more cash intensive process.
Got it. Now, is it similar in the fact that upon redemption you'll get those premium bids back, or is
Yes.
that forfeit?
No, it's not. So on redemption, you get your tax plus interest plus your surplus.
Okay.
And so surplus is again a way to control interest rate and to control bidding from getting untethered from the collateral.
Got it. Okay. So it's for anybody on or listening that is familiar with Colorado, where you don't get those premiums back. In DC, you do, which is why you probably see premiums going a little higher than you would in Colorado, for example. Premiums aren't as high because it's lost money. You're not getting that back on the redemption or not. DC, you do get that back. And you mentioned the high bid premium, or that I guess the 10% of any amount above 40% of assessed value. Was that
20%?
That is also returned upon redemption, correct? Okay.
Absolutely. And it's funny. I mean, it goes to show what a interesting and differentiated business we have. The idea of a premium that you don't get back is so foreign to me. It's going to take me a while to get over that. But it makes sense. I mean, every sale has its own dynamics, and you just price it in.
Yep, you got to account for it. Okay, well, I want to move on kind of the next basic thing of how interest works, but I think it's probably easier to start with, we'll do reverse. We'll start with DC, since it's one jurisdiction, one way, and then we can kind of, hopefully you can help us understand Maryland and how that differs greatly from DC. So how does the interest calculated in DC?
So you get 18% on the taxes due. You don't get anything on the surplus. So you'll see bidding in the current environment on improved properties in the single digits, like in a lot of jurisdictions. In DC, you can purchase sub-year taxes. We have had situations in the past that they are trying to cure, where they would sell the same property over and over and over again. And because we're judicial and a slow judicial process, you could have 3 or 4 different years with 3 or 4 different buyers all in the same litigation. You can avoid that as a buyer by purchasing sub-year taxes. It's a bit cumbersome, as many things are dealing with the Office of Tax and Revenue in DC, but it can, but those earn a pure 18%. And so part of the reason for the desirability of the jurisdiction is being able to purchase sub-year taxes.
Got it. So kind of, I guess I'll say similar to New Jersey in the respect that you won't get as much return off the bat, but as you buy those subsequent taxes, assuming that's part of your strategy and you're earning that 18%, then the blended rate overall starts to rise from that point on the properties
True.
that don't redeem anytime quickly, correct?
True. The only, additional calculation that you have to include when you're dealing with DC is getting your money back isn't something that happens quickly. Starting at the sale. In the sale in DC, you have to have money on deposit. If you have more money on deposit than you end up spending, you're not going to get that money back for 4 to 6 weeks. At certain numbers, that starts eating into your rate of return pretty significantly. Likewise, with redemption, at different times over the last 15 years or so, I mean, there have been times where getting your money back on redemption can take months, many months sometimes. And you're not earning interest at that point. I mean, when the account gets paid is when the clock stops running. And if you don't get that check back, it's a real source of stress, particularly for institutional buyers for whom it can be a lot of money.
Have you seen through COVID in either Maryland or DC that the timeline has been stretched longer than normal because of the situation counties find themselves in, or has it been basically the same?
In Baltimore, we found that a lot of stuff was sold in Baltimore this year that shouldn't have been. And so we're seeing a higher rate of cancellations in Baltimore than we've seen in the past, at least on the work that we're doing. And all of those cancellations are zero interest cancellations. And so, 3-4 months until it posts as having been redeemed months earlier. It's irritating, but you deal with it.
You deal with it. It's just part of the business.
Other jurisdictions are chugging along just fine. We have some counties that will send you checks on a weekly basis, or ECA, put your money in on a weekly basis. Others, it's monthly. But we haven't seen, outside of Baltimore and DC, we haven't seen significant delays.
Got it. Okay. All right. So I guess just to reiterate, interest in DC is essentially 18%, but you don't get interest on that premium, which obviously brings down the blended return. You do get a pure 18% on all subsequent taxes you pay, helps bring that interest rate back up. So DC is pretty straightforward. Now we'll shift into the beast that Maryland is. How's interest calculated in Maryland?
So every county has the right to assess a different interest rate. We have a range from 6 to 20 in terms of counties that we've participated in. Your suburban counties and Baltimore are much higher. Prince George's County, which is the neighboring county, a DC suburban county, is a very large sale. 900,000 people live in the county. That's a 20% county. Baltimore, Montgomery, 18. You get to some rural counties, you'll get to 12, 10, and further down. There's no real subs opportunity in Maryland. You're typically looking at 1, maybe 2 years worth of taxes. You have to be careful. There are roll-up situations where you'll have multiple years of taxes, particularly if there's a foreclosure in front of you that someone abandoned because their bid wasn't good, or they just didn't like the collateral. And so while that was pending, you might have 1, 2, 3 years where the taxes were sitting. And so those could get rolled up into a subsequent year. But typically you're looking at a year or 2 of taxes in Maryland. And you're typically looking at somewhere in the teens in the larger sales, bid down because of the high bid premium.
Got it. So the calculation itself is similar in the fact that you've got the high bid premium, no interest on that, right? You've got the lien itself, which does earn interest. That interest rate changes, by county. So that's something that folks on will certainly need to, if you plan on going to a sale, make sure you understand what the rate is there. Obviously 20 is much more appealing than 6, and probably affects that high bid premium amount, I'm sure. But the calculation, once you know that interest rate is roughly the same, the only thing you can't account for is multiple subs, right? So it's just going to be a flat, whatever your blended rate is between 0 interest on the high bid premium and the rate on the interest or on the delinquent amount itself. That's going to be what you're earning.
That's what your rate of return is. Yep.
Got it. Okay. Interesting. Okay. So we'll get into I'll say the juicy stuff as far as the redemption process and then eventual foreclosure process. And maybe we start with Maryland because it's a little more straightforward and shorter. So can you describe how that works, the redemption period, and when does it stop? When do you have to start foreclosure? And just kind of walk us through that whole process for Maryland.
Sure. So in Maryland, for 4 months after the sale, the purchaser can't do anything. After 4 months, you can begin noticing, and we have statutorily required noticing by certified mail to the owner of record and lender of record if there's an active mortgage. And so that certified mail has to go out. You can begin anytime after 4 months, but you don't have to begin immediately at month 4. A lot of that depends on the buyer's strategy. If you're trying to drive redemption quickly, that's one approach that you could take. If you're happy with your bid and you're happy with your rate of return, you might not notice as quickly.
Is there a time, like you have to do it by such and such time?
So the certificates in Maryland void after 2 years. Okay. So you have to have started your foreclosure process 2 years after the date of the sale. So there's a lot of room there to decide how quickly you want to move. And I've noticed different buyers having different strategies. Some folks will wait till late in the game. You have to be cautious there because taxes are racking up over that additional year or two. Some folks want noticing out at 4 months and a day, and then at 6 months after the sale, you can begin your foreclosure process, presuming you've done your noticing in a timely way. In Baltimore, the rules are a little different. We've had recent changes to the statute that extend the period of time before a suit can be filed. There's more and more political pressure, particularly in Baltimore, to adjust the rules and become more owner and tenant friendly, particularly in owner occupied, but not exclusively in owner occupied. So you need to always be careful that the terrain hasn't shifted too much in Baltimore from one sale to the next. So the redemption period is referred to, if you look at the county materials, they'll say there's a 4-month redemption period, but it's really that there's just 4 months before your next benchmark. You can redeem in Maryland anytime up to the entry of an order foreclosing the right of redemption. Okay. And even at that point, you'll have redemptions.
Got it. Is there any sort of required, I'll say, distance of time between the notice and the start of the lot? You said 4 months is typical, and 6 months, but you have to have the noticing done before you start the lot. Can you do it at 5 months and 30 days and then start foreclosure at 6 months, or does there have to be a time?
Yes, but you have 45 days. Your last notice has to be 45 days. No, I'm sorry, that's in DC, keeping my days straight. In Maryland, you just have to do it. And basically, if you do it on month 4 and month 5, then you can file.
Got it. Okay. And that you can start it at 6 months, no earlier than 6 months, but you have up to 2 years to start the
Yes.
process, or 2 years
To start the process.
Okay.
So there'll be some places where not particularly, some of the counties will post on their website, for example, the certificate is void after 2 years.
Mhm.
What they really mean is it's void after 2 years if you haven't filed your action.
Got it. So as long as you start that process within the 2-year time period, then however long that process takes, you're still okay.
Correct.
Got it. Okay. All right. So how does that differ from DC?
So DC in recent years has an even more demanding process for certificate purchasers. We still have the same 4-month cooling off period, basically, in which nothing can be done. But then the certificate purchaser has to go through the process of actually posting the property themselves. The jurisdiction won't post it. And so you have to post the property with a notice, and the notice is available on the Office of Tax and Revenue website. That basically is multiple pages, but it's just a tax bill and a notice saying you're in tax sale. And that has to be taped to the door. If it's vacant land, has to be on a stick in the middle of the property. But you go through that process. That has to be done after 4 months from the sale, but at a minimum 45 days before filing. There's no certified mail notice that the tax purchaser has to send out, but you have to wait for that process, and then you can go ahead and file your lawsuit. That lawsuit would be 6 months, again out. The difference in DC is you have a 1-year statute of limitations, so you have to get your action filed 1 year, but it's 1 year from the date of the certificate, not from the date of the sale. So there's a little bit of wiggle room there. If for some reason the city is slow on getting certificates out, it can give you a little more space in terms of when you get your case filed.
So instead of 2 years, you have 1 year to get it started.
Correct.
And not from the date of the sale in DC, but from the date the certificate is issued. So you might have a little more than a year.
Right.
Okay. But you don't have to be complete within that year. You just have to start.
No, and in the District of Columbia, you will absolutely not be complete within that year.
Okay. So how does that work with subsequents in DC? Because of my understanding is DC can take multiple years to get through that whole foreclosure process. So you can continue to buy subsequents even beyond
Yes.
that 1 year.
Yep. So we have a half-year billing cycle, and so on that cycle, you have to get in touch with the tax sale unit. They'll tell you, and you'll say, we have 20 liens from last year that are still open. We want to pay the subs on these particular squares and lots, which is our parcel identification numbers, and they'll essentially create a bill for you. It's a special bill kept within the tax sale unit. There's been a lot of work on the IT side at OTR in the past year. We're going to see if that makes things better or worse, but they'll process that bill for you, and then you have to go in and pay, always certified or cash, and then any buyer who buys subs should be very aggressive about tracking their own subs, because there's sometimes a disconnect in DC between the original lien, which can get redeemed and you can get a check one day, and the subs, which can be, you can get that money back weeks or sometimes months later, even though the property owner has paid the account to zero on the same day with the same money.
Huh.
But it's not always tracked in the same process by DC.
Got it.
And
so don't rely on the county at that point.
no.
Got it.
No, I mean, there are many good, hardworking people at the Office of Tax and Revenue, but it is a process that will drive any tax sale purchaser to distraction. And we've had, at every sale, almost every year that I've been to, there'll be a large hedge fund or institutional player who will come to DC for the first time. And after that 1 year of dealing with the idiosyncrasies of the Office of Tax and Revenue, they'll say that they're never coming back. There are other institutional players who do very well and have very sophisticated operations that can deal with DC, and it makes sense for them. But there always seems to be one very large, very aggressive buyer who hasn't factored in just how difficult dealing with the city can be.
Got it. So it's, call it hard, but in some ways it's a barrier to entry, right? If it's harder to deal with, those that can work out a system that deals with those idiosyncrasies, have a leg up, right?
Absolutely.
And okay, so that first sub, 6 month, that first sub makes total sense to me. And then, maybe that next sub, 6 months later, because you will be within or have just started that foreclosure process. So help me understand why you may have, multiple years of subs you can continue to pay, why that, foreclosure process is that just because sometimes the foreclosures last that long, or is it always an elongated process that's going to take you into 2-3 years, and that's why you have that ability? Explain that a little bit more.
It would be very rare in DC for a case to get to judgment in under 18 months from filing. Mm-hmm. So you're now at 2 years from issuance of the certificate. You then go another, beyond the lower end to 2 years out. We had a case that just resolved the other day, finally, that literally has a 2010 date on the initial filing.
Wow.
There's a variety of reasons why that can happen, usually related to estates or multiple family members who will slow the process down, and typically a very forgiving court process. We don't really have statutory payment plans, but the case can just go on in DC, and that functions as a payment plan. So typically you're looking at a 2 to 2.5 year process to get to judgment, and that would explain why you might buy those subs for more than a year.
Got it. So I want to use that example you just mentioned of the lien that was purchased in 2010. Do you, knowing that it's being stretched out, do you continue paying subs for that entire 10 years, or is at some point you go, okay, well, we know it's going to end up in an eventual ownership, why throw more money at it? Or if you don't buy those subs, do you have the risk of somebody else coming in behind you buying that and then filing their own case in a year? Can you explain kind of the risks you run with either route?
Sure. So both those risks are real, particularly in cases of that vintage. In that particular instance, there were multiple buyers of subsequent year taxes. Our client in that particular lien was no longer active in the industry. This was an outlier that they were just waiting to see what happened, but they were no longer an active purchaser in the district. And so other people would buy in subsequent years, and I think there were 4 different cases involving that particular lien, with 4 different attorneys, with 4 different publications, with 4 different postings, 4 different service of process. And so those costs all had to get figured out either in a redemption process or in a deed process, because whoever of those 4 purchasers takes that property down has to pay everybody else who's holding a lien. That's happening less and less, and there were some changes in the process that are designed to prevent multiple year taxes from being out there with multiple cases, but we still see it.
Got it. So in that in that instance where, you may end up with other lien holders, right? Because you didn't you didn't pay the subsequent taxes. Is it a situation where you were first, so you will have first right to that deed, or is it yeah, you may have been first, but if your attorney doesn't stay on top of it, the other guy may come in, do it faster than your attorney. All of a sudden, they have the deed. They just happen to pay you off with interest, and you no longer have rights to that property. Is what?
Correct. It would be the latter. It's the first to get to the order.
Okay.
Foreclosing the redemption. Sometimes different buyers have different business models, and some folks just want the interest and they're happy to let someone leapfrog them. Other times it might be because it's not being aggressively prosecuted.
Got it. So it just depends on what your model is. Like you said, some prefer that and some would be mortified by that situation.
Correct.
Understood. Okay. Are there any other pieces of that foreclosure process that we didn't touch on that we should know about, whether in DC or Maryland?
So in DC, the key, I think, is understanding just how long the process is going to go. We also have something new in the statute in DC that came out of some of what was viewed as abuses in the process after the financial collapse, where on owner-occupied and homestead properties, there's a lot of pressure to keep those out of the sale.
Mm-hmm.
If they are in the sale, and if they go all the way to order, there then is a statutory process that's a bit like a unicorn. None of us have seen it yet, but where there's then going to be a trustee's sale so that equity isn't entirely stripped from the property owner.
Okay.
And where the certificate owner gets the lesser of 10% of the sales price, or $20,000 over and above their redemption at a sale. So it sort of morphs from a tax sale to a bank foreclosure where the certificate owner has certain rights. We haven't seen that happen yet because I think the few times it's gotten close, there are enough legal services organizations that they've been able to shepherd the process to a sale or to a refi or a reverse that will solve that process. But there's something lurking out there, and in the rare event that people were able to get a judgment on an owner-occupied property, it doesn't operate under the old rules.
Got it.
In Maryland, it's a lot faster. The courts, generally speaking, have much less tolerance for delay, including delay by property owners, including delay by owner occupants. I had a call with a judge on Friday afternoon on a case that is less than 6 months old, where he said, "You've done this, you've done this, you've done this, you've done this. I'd like an order in my chamber next week." Meanwhile, we'd given the property owner a payoff statement for the legals portion of the case all of 2 weeks prior. I'm going to do what the person in the black robe tells me to do, but I have no objection, and my client has no objection to the individual redeeming. But the court has no interest in any excuses at that point. I think that is a county by county situation. That's a judge by judge situation. But we definitely see that. I've seen recently, I was looking at some properties in a rural county that neighbor one of a client of mine's that have gone through tax sale. We're seeing judgments in 4 months. In other situations, it might be a year or 2 years before something goes to order, but that's largely driven by the attorney and by the buyer. If you have your foot on the gas in Maryland, and if that's your process, typically you're going to get your judgment quickly if the owner doesn't participate, and if there are no truly unusual title problems.
Got it.
Estates, multiple generations of estates, those sorts of things.
Got it. So in general, Maryland's just a lot faster than DC.
Yes. Yeah, and particularly, the circuit courts in large counties have to deal with criminal cases, divorce cases, all those sorts of time sucks. If you're in a rural county, you have a judge who's happy to process and close another case, because all that gets tracked in Annapolis, in our state capital. And if you have a high closure rate, you get recognized for it. So they're happy to move the merchandise.
Got it. So rural counties move a little faster than urban counties in general,
if you want them to. One of the problems is some purchasers may find themselves in a situation where they don't want to move all that quickly, because there is law in Maryland that a property owner, or the county, though the counties don't typically do this, but where a property owner can hold you to your bid, and they can say, you bid $150,000 for my $50,000 house. I confess judgment. You have to come pay. And there have been some large purchasers who have been burned in that situation, where there have been orders for them to make good on their bid.
Got it. And they don't have the cash to do it at that point in time.
Or they don't want to part with it.
Right. Got it. Interesting. I've never heard of that situation. So I guess to kind of reiterate, is basically that amount that you bid up to where the high bid premium starts, right? That 40%, or anything above that, the other 80% of the amount above that you bid that you didn't necessarily have to pay, when that final order comes down, you have to pay it, right?
Yeah.
So it's basically, would I be accurate in saying maybe that's the defense's attorney being clever in trying to drive that to that point, and then if you can't come up with it, does that help them in any way? Is there incentive on their end from the defense standpoint to drive it to that point and you not being able to pay that amount?
If the bid is completely out of whack with the collateral, the surplus bid, not the surplus paid, but the amount over the overbid, the owner can collect that. So if your house is worth $50,000 and there's a $150,000 bid because someone was just relying on what the Department of Assessment and Taxation says it's worth, not what it's actually worth, you're entitled to that $100,000 differential.
So you may find, I guess, somebody that's helping the prior attorney or prior owner really recover that excess bid in that situation.
It's exceedingly rare, but it is a risk factor that people who are bidding without a lot of knowledge as to what they're bidding on have to be aware of. And there are ways to avoid that process, but it's just another warning that there's some ways that you can really get bitten if you let the bidding get away from you.
So do you have a time limit? Once you're required to bring that additional money, to be paid, right? That surplus to be paid. Is there a time limit from the time that the judge says is paid till you must pay it or you lose your interest in that property?
So the county has to come back in and vacate the judgment. They routinely will do that after 6 months to a year.
Okay.
If you haven't paid it. In DC, there are some statutory limitations. You have to do this by this point, this by this point. But the Office of Tax and Revenue can't get you a bill fast enough for you to meet those standards, so they are observed really in the breach. In Maryland, it is not unusual for tax sale purchasers to get all the way to judgment and then not close on the purchase, at which point the county gets irritated because they've waited for a couple of years while your case has been chugging along, and they will then move to vacate the judgment. They are not typically holding buyers to their bids.
Got it. So what does that vacation, what does that do? Does that mean you as the investor lose whatever
Everything.
amount you lose? Okay. So you're forfeiting that at that point. If you don't come forward with funds, you're giving up whatever. It's not like you get that back. You forfeit it, including that high bid premium amount, everything?
Everything zero, your legals, your publication costs, which in rural counties in Maryland can be incredibly expensive. We have, you know, in many of these counties, there's only one newspaper. You can see publication costs of $600, $700, $800, and that's all a zero.
Got it.
If you don't go to deed.
Interesting. I guess a follow-up from a comment you made a little while ago, Charles, on that unicorn sale in DC, right? Where, you know, you said, I think 10% of whatever amount is bid goes to the 10% above the lien amount goes to the prior owner.
Goes to the certificate holder.
Certificate holder.
Not to the prior owner. This is a way to maximize how much goes back to the property owner.
Interesting. Okay. So how much, so in DC, is it similar where whatever surplus is bid at the auction, and then assuming whatever that unicorn sale actually ever takes place, whatever surplus is bid there, is that also due to the prior owner of the property?
No. The surplus in DC is kept by DC.
Interesting. Okay. So it's opposite from Maryland.
Yeah.
Okay.
There's the foreclosed owner doesn't currently have the opportunity to go in and say, DC, you got everything you were due. I want what I'm due. I would anticipate, there has been some litigation on that. I would anticipate there's going to be more. It doesn't seem equitable. And in fact, on years where there are, likewise in years where there are multiple surpluses, all of those on the redeemed side get paid back, but the city is still, you know, having use of that money for multiple years of different people's surpluses.
Interesting. Yeah, I know there's some pretty large lobbying groups out there that are trying to, there's a case going on, or I'd say more of an argument or litigation going on in Arizona around that whole, it's different in the fact is because there's not necessarily premiums, but it's similar in the fact that it's a foreclosure process administrative out in Arizona, right? And the lien holder can end up owning the property for a lot less than the property is technically worth, and there's really nothing there for the prior owner. And so there's a lobbying group that's trying to change how that process works to unlock that equity that's due to the prior owner. So I would anticipate, like you said, that at some point, those groups that seem to be very well funded will be wanting to change that in DC as well.
Yeah, I would anticipate that. And one thing that we don't see a ton of, and I think it's because of the power of the counties, but I haven't seen a ton of downward pressure on interest rates. There's plenty of downward pressure on interest rates for buyers, right? The market is solving that problem.
Right.
But the county is never incurring that loss. They're always clipping 18, 19, 20%, 12% credit card rates on collateralized property. Mm-hmm. And I'm surprised that there isn't more downward pressure on the counties to reduce that rate of interest that people are having to pay on delinquent taxes. I anticipate post-COVID that's going to be an area of inquiry.
Interesting. What I'm sure we can go down a lot of these other rabbit holes too, but in general, the process from the time you buy the lien to the time you hold the deed is, how long does that typically take in Maryland?
If your goal is to get to deed quickly, you should be able to do it within a year.
Within a year, okay. And then for DC, how long is that? You said at least 24 months.
at least 24 months.
So 3
You
years.
know, I think if you have your foot on the gas and if you're not dealing with unusual situations, you're talking about 2 to 3 years. The bulk of what is going to deed in DC at the moment is unimproved, special situations, alley lots, things where a small universe of buyers, typically not with institutional financing, because I know that there's some limitations in terms of institutional financing on what you can buy. So local players, sophisticated local players are able to make sense of some of those vacant lots, alley lot situations. Grandma's house isn't going to deed in the District of Columbia anymore. 15 years ago it was. There are so many wholesalers, bird dogs, you know, whatever you want to call them, hunting for those properties that they're going to all get sold before they go to deed in DC. And so folks who are looking for that opportunity.
Got it. So there's all these other avenues there, or people working with the prior owner, they buy the house and then they settle that lien and redeem that lien before it ever gets to a deed.
Back when we used to have live hearings, you know, a year ago, because we have live hearings in tax sale cases every Wednesday in the District of Columbia. Not every case, but every Wednesday, there'll be hearings on some of them. And you'll have 3 or 4 people in the courtroom doing nothing but bird dogging properties to try to figure out how to snatch them before the tax sale purchaser can.
So it's for anybody looking to buy liens in DC with the goal of owning, you know, higher end real estate, probably need to be a bird dog or work with a bird dog, because buying the lien and assuming you're going to end up with the ownership is not an avenue that works today anyway.
No, and I tell people in both DC and Maryland, and I think this is true for much, but not all of the industry. This is not a bricks and mortar business where I do it. This is a paper business, and my clients might be in the bricks and mortar business and other aspects of what they do, and this can be complementary to it. But if you're a one-off buyer who's saved your hard-earned money to go buy the house that you think you're going to be living in, this isn't the business to be in these jurisdictions, because anything that most of those folks are going to want to live in are going to redeem. There's just a situation where someone's been just recently moved to a nursing home, or someone died and an estate has to be opened up. Obviously there are opportunities. I hit that opportunity at my very first sale, but that was by luck or by volume, not because that's what the business in these jurisdictions is all about.
Got it. Now, does that hold true for Maryland as well? I mean, DC obviously, but Maryland as well?
So if you want to own property, there are some places that you can do it. I'm not certain that the bids required are supported by the collateral. I think most of the folks who want that are going to find themselves just overbidding the professional lien purchaser to a point where they might get burned if the property doesn't redeem. But it's possible. The opportunities aren't as limited as they are in the district, but I'd be careful. The one caveat to that is Baltimore, which is an entirely different universe. The buyers are different. If you look at who buys in Baltimore, yes, you're going to see the institutional names that we all know in the industry. You're going to see large names in Maryland that we all know, but you're also going to see names that are unique to Baltimore, where folks are trying to roll up, 2, 3, 4, 10, 20 townhouses, which can be purchased very cheaply. they can also be sold again very cheaply. There's not a ton of appreciation in a lot of those neighborhoods. There is in some. And so for folks who are looking to take down bricks and mortar, we see it in Baltimore more than we see it in other places.
Got it. Interesting. Okay. Well, good to know. I guess before we get into the title aspect, I think we kind of, I failed to ask you about really the attorney fees, right? So this judicial process, so attorneys' involvement is a lot in Maryland as well as DC compared to some states. So I'm assuming there's fees associated with those, and do those fees earn interest, or are they redeemable, non-redeemable? How does that work?
Sure. So in Maryland, because we have the noticing process, you can see fees for the noticing, which are capped by statute at $500, and running your title abstract, which is capped by statute at $250. So you're looking, in addition to certified mail, at statutory fees of about $750 pre-filing. Post-filing, you have additional fees that accrue up to $1,300, $1,500 in the event that what's called an affidavit of compliance, it's really a motion for judgment, is filed, plus all of the costs that are associated with that: service of process, publication, sheriff's fees, filing fees. So that's what happens in Maryland. All of those are reimbursable from the property owner at redemption. In some counties, the county collects that amount and remits it back to the tax certificate holder. In some counties, it gets paid to the attorney's office, at which point a release is generated. That release is then taken to the treasurer and the taxes get paid. And that's true both in the pre-filing and post-filing process. In the district, even though you're posting prior to filing, that cost, there's a statutory cost, and that's just entered into the tax bill once certain time benchmarks are hit. So after 4 months, OTR is just going to add that posting expense. Legal fees are only reimbursable from the property owner after filing the lawsuit.
Okay.
We used to have uncapped attorney's fees, and that was the subject of a lot of litigation. There was admittedly a good deal of abuse by certain participants in the process who aren't in the industry anymore, to my knowledge. That's largely been washed out by a fee cap process that has been, for the most part, just taken from the Maryland statute and inserted into the DC statute.
Okay.
It doesn't account as well for the fact that a DC case can take so much longer and have so many more actual live court appearances than you're ever going to have in Maryland. In Maryland, you typically don't have court appearances. In DC, court appearances are regular. So there's a gradation of fees that can be charged. Typically, if a property redeems while it's been in suit for a few months, you're looking as a property owner or as someone paying an attorney to do this for you for fees of about $2,400-$2,500, including expenses. Those are all reimbursable by the property owners. They do not earn separate interest.
Okay.
And don't get capitalized into the lien at any point.
Okay. So they're reimbursable. So it's not that you have to pay it and you never get that back. They are reimbursable, but no interest paid.
Correct.
In both DC and Maryland.
Correct.
Okay. Now, because it's so, I'll say, intensive for the foreclosure process in both areas, Maryland and DC, when do attorneys, or when does your firm typically get involved for third parties? Is it at that first notice that's sent, or is it before then? When do clients typically start involving you or attorneys?
The bulk of purchasers who are buying any sort of volume, so the non-civilian purchaser buying a one-off lien for the first time, are typically going to have existing relationships with one or more attorneys that might handle things depending where in the state it is, what sort of lien it is, how they feel at any particular moment. And that will largely hit on the 4-month period.
Okay.
Where they'll say, okay, we're placing these with you. We have 100 liens. We want notices to go out on all of them. We want notices to go out on some of them, but they're being placed at this point. And then you'll go through that process. We have, since I go to a decent number of sales, folks will come up to me and say, I won this one lien, can you handle this for me? And I'll typically say to those people, give me a call in 4 months, or I'll call you in 4 months, because there's nothing we can do now, and you don't want to have an attorney until you need one. And then we reconvene at the 4-month period, at which point I might tell them, you bought something that's worthless, in my opinion. Someone else might have a different opinion, or let's get the process going. And different firms will handle different ways what the certificate holder has to put up in terms of a deposit for expenses, for fees, and that is largely driven by if it's a one-off process or if you have a long-term relationship with a significant buyer.
Got it. So is it something where, because it is a judicial process, those notices, all of that is required to be done by an attorney, or is it a situation where, I guess it could theoretically be done by the investor, but because of all the nuances and reasons for being thrown out, it's just highly recommended that the investor doesn't do that notice themselves? Is there?
So in Maryland, the purchaser could send their own notices out. The legals are set statutorily, so for many purchasers, it's essentially a free ride where the attorney is typically going to be willing to handle the noticing process, knowing that they're either going to get paid by the redeeming property owner, or it's going to go into suit, at which point a different fee agreement might be reached. So we don't see a lot of self-noticing in Maryland. We don't see a lot of self-representation in Maryland. It does happen, but we don't see it so much. In DC, with the posting, owners can post and provide that notice. Again, it's rare.
Got it. Okay. All right.
None of the institutional buyers that I know of are doing it with no involvement of their attorney. They might do it themselves, but the attorney's going to be involved.
Got it. There might be their general counsel.
Right.
Got it. Okay. I want to shift gears a little bit to, I guess, the state of the title after that foreclosure. I know it's a judicial process, but is what you get on the other end of it, is it marketable title? Meaning, can I go sell that property through a title company with title insurance with no additional requirements? Or is it something where you have to go through a separate quiet title? Or is it something where you just have to wait a period of time and you have that insurable title? I guess, what does that title look like from an insurability standpoint post final judgment?
So in Maryland, we haven't run into significant challenges on being able to sell properties for our clients after they go to deed. I think for some of the cases that I've looked at, oftentimes where folks are self-represented or by by parties who are represented by folks who don't do this work regularly, I would be more skeptical of the quality of their title. But for the most part, if you're dealing with the dozen or so firms in Maryland that routinely do this sort of work, I think you're going to be in pretty good shape. All of the properties that I've been involved in the past 3 or 4 years that have gone all the way to deed and then been sold are either abandoned or largely in disrepair that that have had a value sub $250,000, let's say, where I think the title company typically has a lot more flexibility, where a good title company has a lot more flexibility to do their internal underwriting. I think if you're starting to approach 500, 750, $1 million, there might be more resistance, and particularly resistance from some of the major underwriters towards tax title. But we haven't seen that problem in Maryland. In DC, there has been a lot of resistance to underwriting tax sale cases. I think a tax certificate purchaser is well served to have relationships with settlement companies that they know can close a tax sale case. It doesn't even always correlate to what the actual title insurer is. There are only so many of them, and some of them have reputations for being very resistant to tax sale cases, but with the right settlement company that I guess has a higher level of confidence from the insurer, they can get them closed. We've seen resistance, but we've also seen the ability to get them closed. Again, if you're dealing with multiple generations of deceased, you're going to have some issues. Mm-hmm. If you're dealing with a fairly clean case, it's just a title sale case, you're not going to be forced to, or tax sale case, you're not going to be forced to go the quiet title route. We have done it for some clients in some situations as a belt and suspenders move, but it's not something that is required or customary.
Got it. So it's more of a rarity as opposed to the normal in order to do it, but it is an option, right? If there is resistance, then you can go the quiet title route. I guess there's more cost, more time,
yep.
But that is an option. Is there a statutory length of time you could wait? Like, do you have that option too? I'll use Florida, for example, since everyone's familiar with Florida. You can just wait 4 years if you want. Does Maryland or DC have something similar?
We have a 3-year statute of limitations in both jurisdictions. That would be, for clients who, for example, are buying raw land, if they anticipate a problem there, they might wait 3 years or build on it themselves if they have enough confidence in it. And after 3 years, more of the title insurers are going to say, fine, no one's come out of the woodwork. We have a statute of limitations argument. Move forward, we'll do the transfer.
Got it. Interesting. Now, that's from a marketability, title marketability standpoint, but is Maryland and DC similar to, I'd say, most states out there where there are some liens that survive? Obviously, mortgages probably get wiped out, probably maybe mechanics liens, but do let's say municipal fines, municipal liens, HOA liens, are there any fines or liens that survive the whole process? And even though you've got this deed, you now inherited those fines as well?
So in DC, they have to be what we call certified, which essentially means they have to be recorded. And what we're primarily dealing with there are municipal infractions, which come from a different office in DC, the Department of Consumer and Regulatory Affairs, which also has the ability to put a property into a blighted status, which can really dial up the sub-year tax exposure. to a 10x multiple in some cases.
Oh, wow.
So you have to be careful in terms of dealing with DCRA and with DC Water and Sewer. If those are certified, then they attach, and you have to deal with them in most circumstances. In Maryland, if you want to get your deed chopped off on by the treasurer, and particularly if you're in a place where they're in a county, but where your property is also in a separate town, you're going to have to get the town stamp as well. I'm of the view legally that if they haven't recorded those infractions, the certificate purchaser isn't on the hook. And some of these towns, I don't know what landscaper they're using, but it's $200, $300 every time they mow the lawn on some abandoned property. As a practical matter, those liens get paid, and they're going to survive. So you do want to have some sensitivity to whether you're in a town or if you're going to have other exposure to municipal infractions. With the IRS, we notice them, go through the regular process of letting them get involved. They never do, and you move on. So you should be good there. But I would be wary in both jurisdictions of grass cutting charges and other charges that can accrue, because they can, again, on the example of a $10,000 property that has $2,000 worth of grass cutting fees, it can make the math not work.
Right.
And every time I've tried to have that conversation with a town or with a county, they say, we see guys like you every year, and you always come in and you tell us how you're going to do the right thing, and then you go back across the bridge and go back to Washington, D.C., and we never see you again. So it's just a risk that you have to factor in.
So it's like most states, right? You might have insurable title, but that doesn't mean that it's free of any other encumbrances, right? You're going to have to fix those other encumbrances in order to sell the property with title insurance, regardless. But it sounds like I know there are some states where you can kind of negotiate with the municipality and say, okay, I understand there's a $5,000 fine, but can we settle at $1,000 instead of $5,000? Does that sort of thing happen in Maryland or DC, or is it this is your bill, either pay it or pay it or don't, but it's stuck?
In Maryland, my experience has been that the towns don't negotiate.
Okay.
That these municipal infractions are a central part of their business model, and maybe the local lawyer can work a deal, but someone who's operating statewide for multiple institutional clients, if they see an address in New York City or Los Angeles or whatever, they're not interested in making a deal. In DC, there are some issues where you can point out to DC how they've been wrong in terms of shifting something into blighted, or where the bill is duplicative, and it's just been entered into the computer wrong. There is the ability to work actually there a little more successfully. You're also talking about bigger numbers.
Yeah.
So if you're working with them in a real constructive way, there's more flexibility on the non-tax amount. They won't typically. It is very unusual for there to be an adjustment of the taxes.
Got it. Interesting. Every state has its nuances. Charles, I can think of probably 50 other questions and rabbit holes we can go down, and I'm sure our viewers have questions of their own, and I certainly encourage everyone with those questions and looking to get active in Maryland or DC to reach out to Charles. Your contact information will be up on the screen here shortly. So please, everyone, do that. my last question is kind of a send off. I like to ask everybody is what is the number one pitfall or pothole you're aware of in DC and Maryland that maybe investors fall into that is pretty easy to avoid if they just knew that one piece of information?
So in the District of Columbia, the biggest risk you face is that your true counterparty is the DC government, not the property owner. And if you don't have the capacity or the flexibility to deal with that counterparty, you're going to have problems. And so you need to include that as part of your strategy in terms of understanding how difficult that can be. In Maryland, the key mistake, the point where every problem in the process is birthed, is at the bid. If you bid too high, there's nothing you can do to unmake that mistake, and that will come back to haunt you. And it's not going to haunt you in year one if you're a new buyer in Maryland. You might not even see it in year two, but that tail is always what ends up coming back to eat into your returns, where after you've gone through that process, you say, hold on, we have half a dozen zeros here. How did that happen? And it's all because of what happened at the sale.
Got it. So in DC, just understand who you're dealing with, what it boils down to. And in Maryland, it's better have your bidding strategies figured out. Don't overbid, because that'll come back to haunt you. Yeah.
And a lot of times because properties redeem, and they redeem, at 80, 90% rates, depending on what type of property you're buying, we don't see our mistakes, and we don't have to eat our mistakes. But when you're made to eat them, they really, really hurt, because it's not with a single digit return environment, which we're seeing in these two jurisdictions. A few zeros is going to make the year an unsuccessful year.
Right. That one mistake out of 10 or 20 can still negate whatever gains you had from the other 10 or 20 really easy.
Yep.
Excellent. Well, Charles, thank you again immensely for your time. I learned a lot, always do. I'm sure everyone else on or watching learned a lot, and I hope we get to have you back and talk about some of these other rabbit holes and questions that I've come up with, and I'm sure we'll receive those questions to our email. So thank you again. I appreciate the time, and we'll talk soon.
Anytime, Brian. Thank you so much. Take care.